Hey, good afternoon. My name is Brian Lucier, and I'm the regional property manager from Bel Air Property Management. And last Thursday, I got a call out of the blue by our constable, Kevin Rice. Kevin has been a family friend for me for over 30, 40 years, but he was asking me about a form, wondering if I had the latest version of it. And honestly, I had no idea what Kevin was talking about. So he sent over the documents. I did a little bit of research, and I think that this information that I have for you is critical if you are a property owner, property manager, or in any way do rentals in Massachusetts. Um, there went into law last year, and I think the final amendment was May 11th, 2022. So there's a little bit of a spin on the 14-day notice of non-payment of rent. Typically, in my world, you can do a 14-day notice for non-payment of rent, okay? If you are a tenant at will, if you get two of those within a 12-month period, the third one, you can ask for possession. So that's pretty straightforward. Tenant at will, two 14-day notices, third one, you can ask for possession, move them out, okay? Tenant at will is pretty straightforward. Okay, that's under Mass General Law 186, subsection 15B. If you are a tenant with a lease, month after month after month, if it's a one-year lease, you can file a 14-day notice, and the tenant has the right to cure it every month. So you could end up with a tenant that every month you have to issue them a 14-day notice to quit for non-payment of rent. Okay, so that's the big difference for non-payment of rent, tenant at will or tenant with a lease. Then, if it is a tenant at will, the other type of an eviction you can do is a 30-day notice to quit. It can be no fault, just we need the apartment back, or for whatever reason. Okay, that opens up a whole nother can of worms that I'm not going to get into on this video because I really want to drill down to the CARES Act and what this did to landlords. Okay. Then the fourth flavor of an eviction, if you have a tenant with a lease, is you could do what is known as an eviction for breach of cause. Now, our lease has two very critical clauses in it given us by our attorney, so we have them in there. So pretty much anything in our lease, if it's broken, is a material breach of lease. And the other clause says, if there is a material breach of lease, we can start an eviction process in 7 days. After this video, we may be changing that to less than 7 days. We know landlords who have a 3-day termination clause. So that's something we'll take a look at. Well, let's get into the CARES Act, okay? So again, just to review, 14-day notice for a tenant at will, we talked about that. 14-day notice for a tenant with a lease, we talked about that. Tenant at will, 30-day notice, we talked about that. Well, you can't do a 30-day notice. Well, let me take that back. For a lease, you can do what ours is a 7-day termination clause for breach of lease. Again, this has to be written into your rental contract that if you breach the terms of the lease, it's a 7-day eviction. We have that. So there are the 4 ways that you can evict in Massachusetts. Well, let me introduce you to number 5. Number 5 is the CARES Act 30-day notice for failure to pay rent. Let that sink in for a minute. A 30-day notice for failure to pay rent. Okay, it's not a 14-day notice for non-payment of rent. It's not a 30-day notice for no cause. It's not a 7-day notice for breach of lease. It is a 30-day notice for failure to pay rent. Now, here's the good part. Thank you, Kevin. So to find out more about this, you can go to www.mass.gov/notice to quit. You can get all these forms there. So statement number 1 under the CARES Act compliance refers to the rental as a covered dwelling. Now, what the heck does that mean? We know that for the past couple of years, if you do a 14-day notice, you need to accompany it with the attestation form. This is a new attestation form that you need to use for the CARES Act. So just hold on to that thought for a second, okay? So if you're going to evict for non-payment of rent and your unit falls under a covered dwelling, then you must comply with the 30-day notice for non-payment of rent from the CARES Act. Now, nobody even knows what this is. I talked to my attorney. He didn't know what it was. My constable found out about it because another attorney in Boston had been using it, and he's been noticing that the notices to quit are different. He's up on his stuff. Kevin knows his things. And this was something he never heard of before, so he reached out to me, gave me all the paperwork, and I love to read, so let's keep going. Now, a covered dwelling, brace yourself. The determining if a unit is a covered dwelling under the CARES Act, these are the three prongs. If the properties have federal assistance programs from a voucher or grant program. So that's all of your Section 8, all of your housing authorities, all of your RAFT, any type of subsidy government program or grant program, you're a covered dwelling. So you can't do the 14-day notice for quit. You have to do the 30-day notice for non-payment of rent under the CARES Act. Prong number 2, properties assisted through federally subsidized housing program. See the list that applies. I'll be reading you this in just a second, okay? So federal rental assistance program, voucher or grant, or assisted through a federally subsidized housing program. This is huge. Now it gets better. Properties with federally backed mortgage loans. 25 years. I've never had to ask my client, what kind of mortgage do you have on your building? Just in case somebody doesn't pay rent, then I have to file a notice to quit for non-payment of rent. Never had to know that. I don't think it's anybody's business how you financed your property. However, now it's the law. Okay, so covered dwelling, federal assistance program, voucher or grant, properties assisted through federally subsidized housing programs. I'll get through that list in a minute. And then properties with federally backed mortgage loans or federally backed, it says federally backed mortgage loans and federally backed mortgage loans. What's the definition, right? So, wonderful, wonderful. If your property is mortgaged, this is right off the document, you may need to do some research to find out if it is federally backed mortgage. The Federal Consumer Protection Financial Bureau offers suggestions on how to find out if your property has a federally backed mortgage, and then it gives you a website. And then B, this was all A, determining if your unit is a covered dwelling. Now B, the CARES Act notice requirements. You are required to state whether your notice to quit complies with the notice requirements of Section 4024C of the CARES Act. Never heard of this one. That section prohibits a landlord of a covered dwelling unit from requiring a tenant to vacate a covered dwelling unit sooner than 30 days after the landlord provides the tenant with a notice to vacate. So 14-day notice is out the window. Goodbye, Mass General Law 186 subsection 15B. Everything in there has to do with a 14-day notice. Not everything, but everything having to do with a 14-day notice is in there. Okay? So it goes on. Therefore, if your property is a covered property, your statement of compliance with Section 4024C of the CARES Act means you have provided your tenant with at least 30 days notice before terminating the lease or otherwise requiring the tenant to vacate the premises. No more 14-day notice. So you're also required to provide this documentation, the notice to quit. You have to check the yes box on the attestation. So how do you know if your properties have assisted federal subsidized program or if they have federally backed loans? Well, we've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 different buckets that we need to check to see if we're dealing with a covered property to send a notice for non-payment of rent. Under HUD, public housing, you qualify. Section 8 housing choice voucher programs, you qualify. Section 8 project-based housing, you qualify. Section 202 housing for the elderly, you qualify. Section 818 housing for people with disabilities, you qualify as a covered dwelling. Section 236 multifamily rental housing. Hello, we all do multifamily rental housing. That's everybody else. Section 221D3, below market interest rate, BMIR housing. Those are your subsidized housing projects. Your home, 42 USC, subsection 12741, you're covered. Housing opportunities for person with AIDS, you're covered. The McKinley-Vento Act homelessness program, never even heard of that one, you're covered. And then there's even more. Section 515, rural rental housing, you're covered. Section 514 and 516, from farm and labor housing, you're covered. Section 533, housing preservation grants, you're covered under a covered dwelling. Section 538, multifamily rental housing. Again, I think that's just about all of us. That's a covered dwelling. And then finally, low-income housing tax credit. Well, all these big developments that are getting these housing tax credits, they qualify for that as well. Then you have to fill out the affidavit of compliance. This needs to be filled out, needs to be signed. If you're a corporation, you need to have your attorney do it. And you have to say, yeah, this is a covered dwelling, which now leads you to this. CARES Act 30-day notice for failure to pay rent. This is a new bird in my tree. So you got to fill this out. You got to figure out if you have a covered dwelling, which pretty much if you're collecting rent, there's a high probability you have a covered dwelling. And now your 14-day notice just turned into a 30-day notice to quit. Things are getting better all the time. So what do? I'm a property manager. I've got over 100 different clients. Do I have to get on the phone every time I've got a notice to quit going out on the 3rd or the 5th saying, hey, I need to know, is this a covered dwelling? What kind of mortgage do you have on it? Is it federally backed? Landlords are going to go through the roof when this happens. Relax. Okay, I mentioned at the beginning of this video, we have 2 critical clauses in our lease, okay? That everything in the lease is a material clause. That's right on the first page. The second clause that backs that up is any breach of any material clause is a termination clause, which will kick in that 7-day eviction, okay? So what does that mean? It means if someone's late for rent, we've got clauses in our lease that say you're in breach of lease. I'm not evicting you for non-payment of rent. I am evicting you for the breach of the terms and conditions of the lease. You gotta have a good lease. You gotta have termination clauses. And seriously, after this video, I'm gonna work with my leasing team. We're gonna go through our leases, and I think we're gonna ratchet down our time to 3 days for a termination clause for any material breach of lease. So, if you don't have a lease like that and someone does non-payment of rent, you better know what type of mortgage, or if they have any type of subsidy or housing or grants as a tenant, you need to use the CARES Act 30-day notice for failure to pay rent. You have to use that one. If you use good old-fashioned 14-day notice under Mass General Law 186 subsection 15B, if they've got a smart lawyer, your case is going to get thrown out and you got to start all over again. So, button up your leases. Get those clauses in there. If you don't have those clauses and you don't want to deal with the brain damage I deal with, give us a call. We'll look at managing your properties for you, of course. We'll do that. we're going to ratchet up ours. So we won't be sending out 14-day notices anymore. We're going to be doing a 3-day notice to quit for breach. 3 days. Bang. It's legal. It's in our leases. And we're going to move forward with that. So I wish I was giving you good news. Maybe at the end, there's a silver lining around having a better lease and reviewing your leases and getting those up to date. But just know that the CARES Act is out there. It has been out there since May 11th, 2022. And more and more attorneys starting to catch wind of this. So yeah, if you're a landlord plaintiff, your lawyer needs to know what's going on here. And if your tenant gets a lawyer for a day or some other free assisted lawyer and they're aware of this, your case is going to get thrown out. So, word up, landlords. There's a new sheriff in town, and it is the CARES Act, 30-day notice for non-payment of rent. I hope this helps. I hope this helps in your operations, your rentals, and your property management businesses. This is Brian Lucier for Bel Air Property Management, hoping that this is good news and you can get your wagons rallied up around the campfire here and take action to make sure that this is not going to affect you and you are prepared for what's coming around the corner. All right. Thank you so much for your time. Have a great day.